Ladies and gentlemen, today I stand before you to shed light on a prison that has become synonymous with secrecy, isolation, and the erosion of fundamental human rights, Belmarsh Prison. Officially known as a high-security facility, Belmarsh Prison has earned a notorious reputation as one of the most secure and secretive prisons in the United Kingdom. Located in southeast London, it was originally designed to house the most dangerous criminals, those convicted of violent offenses such as terrorism, murder, and organized crime. However, over time, it has come to detain individuals who do not fit this profile but instead are held under conditions that many human rights organizations have described as extreme and unjust. The comparison between Belmarsh and Guantanamo Bay is not merely rhetorical. It stems from the striking similarities in how both facilities operate. Guantanamo Bay, the infamous U.S. detention center, was established in the aftermath of 9/11 to house individuals suspected of terrorism. Over the years, it became a symbol of human rights abuses, indefinite detention without trial, and the mistreatment of prisoners. Likewise, Belmarsh has increasingly been used as a tool to isolate individuals who challenge state narratives, particularly those who expose government misconduct or classified information that reveals wrongdoing. One of the most alarming aspects of Belmarsh is the extreme level of security and secrecy surrounding it. The prison is designed to restrict information flow to the outside world, limiting media access, visitors, and even basic transparency regarding the conditions inside. This secrecy raises serious concerns about what happens behind closed doors. Without proper oversight and accountability, the potential for abuse increases significantly. Furthermore, the harsh conditions within Belmarsh mirror those of Guantanamo Bay in various ways. Many detainees are subjected to prolonged solitary confinement, often spending up to 23 hours a day in small, windowless cells with little to no human interaction. This level of isolation has been widely condemned by human rights organizations, including Amnesty International and the United Nations, as a form of psychological torture. The effects of such confinement are devastating, leading to severe mental health deterioration, depression, anxiety, and, in some cases, suicidal thoughts. Additionally, the treatment of detainees within Belmarsh raises significant ethical and legal questions. Reports have surfaced of medical neglect, restricted access to legal counsel, and physical and psychological abuse. Some detainees are held in conditions that violate international human rights standards, yet the UK government has largely ignored calls for reform. The justification often given for such extreme measures is national security. However, when national security is used as a blanket excuse to suppress transparency and human rights, it creates a dangerous precedent. The very existence of Belmarsh as a facility that can hold individuals in such extreme and secretive conditions should concern anyone who believes in justice and human rights. A democratic nation should not operate a prison that echoes the darkest aspects of Guantanamo Bay. If the UK wishes to uphold its commitment to fairness, due process, and human dignity, it must confront the reality of what Belmarsh has become, a symbol of repression rather than justice. Belmarsh Prison was originally built as a high-security facility designed to detain individuals who pose a significant risk to public safety, those convicted of violent crimes such as terrorism, murder, and organized crime. It is often described as the UK's most secure prison, a place where only the most dangerous offenders are held. However, over the years, Belmarsh has expanded its role beyond simply housing violent criminals. It has become a prison where political detainees, whistleblowers, and journalists are held, not for committing acts of violence, but for revealing inconvenient truths. This raises an important question. Why would a country that claims to uphold the principles of democracy and free speech imprison individuals who have never committed a violent crime? The answer lies in the way governments sometimes use legal systems to suppress dissent and silence those who expose corruption, war crimes, or human rights abuses. Belmarsh has become a symbol of this suppression, a place where individuals who have challenged the state's authority find themselves locked away under extreme conditions. One of the most troubling aspects of Belmarsh's role in political imprisonment is the treatment of detainees who are not terrorists, murderers, or violent offenders, but rather whistleblowers, investigative journalists, and those accused of leaking classified information. These individuals are often charged under laws that were originally designed to prosecute spies or terrorists, despite their actions being fundamentally different. Instead of being recognized as people who have acted in the public interest, exposing crimes, uncovering government wrongdoing, or holding the powerful accountable, they are treated as dangerous enemies of the state. By placing such individuals in a facility like Belmarsh, the government sends a clear message: revealing the truth can be as punishable as committing a violent crime. This blurring of the line between national security threats and truth-tellers is deeply concerning. It means that someone who exposes government corruption could end up in the same conditions as a convicted terrorist. It also creates a chilling effect, discouraging others from speaking out, for fear that they too could be subjected to the same fate. The psychological and physical toll of being imprisoned in Belmarsh is severe, especially for those who have never been accused of violence. Unlike hardened criminals who may have adapted to the prison environment, journalists and whistleblowers are often thrown into an unfamiliar world of isolation, surveillance, and extreme restrictions. They are kept under high-security conditions, sometimes in solitary confinement, with limited access to their families, legal teams, and even basic medical care. The prison experience for them is not just a loss of freedom, it is a deliberate attempt to break their spirit, to punish them for their role in exposing uncomfortable truths. Furthermore, the presence of nonviolent detainees in a prison designed for the most dangerous offenders highlights the disproportionate response by the state. If someone's only crime is informing the public about government actions, why are they treated as if they were a national security threat? Why are they subjected to the same brutal conditions as those who have caused physical harm to others? These questions go to the heart of what Belmarsh has become, a tool of political repression rather than a facility solely dedicated to detaining dangerous criminals. By holding truth-tellers in the same prison as violent offenders, the UK undermines its own claims to support democracy, human rights, and press freedom. It sets a dangerous precedent, one that suggests that exposing corruption or revealing uncomfortable facts is as grave a crime as committing acts of violence. This not only erodes trust in the justice system, but also weakens the very foundations of a free society. Solitary confinement is one of the most extreme forms of punishment a prison can impose, and in Belmarsh Prison, it is not just a temporary disciplinary measure but a routine form of incarceration. Many detainees, particularly those considered high-profile or politically sensitive, are subjected to prolonged isolation for up to 23 hours a day. This practice has been widely condemned by human rights organizations, including the United Nations, which has classified extended solitary confinement as a form of psychological torture. Despite this international condemnation, Belmarsh continues to use isolation as a tool of control, inflicting severe mental and physical harm on its prisoners. The conditions of solitary confinement in Belmarsh are harsh and dehumanizing. Prisoners are often confined to small, windowless cells where their only human contact is with guards or, on rare occasions, brief visits from legal representatives. Access to natural light, fresh air, and meaningful social interaction is severely restricted. Even basic privileges, such as reading materials, phone calls, and exercise, are limited or denied altogether. In many cases, prisoners are only allowed outside their cells for 1 hour a day, and even then, they are often placed in small, enclosed areas where they are unable to interact with others. Psychologists and medical experts have long warned about the devastating effects of prolonged solitary confinement. Studies have shown that isolation for extended periods leads to severe psychological distress, including anxiety, depression, paranoia, hallucinations, and suicidal thoughts. The human brain is wired for social interaction, and when that fundamental need is denied, it begins to break down. Prisoners who have endured long-term solitary confinement often describe it as a living death, where days blur into each other and the sense of time and reality begins to erode. Some have reported hearing voices, experiencing extreme mood swings, and even losing the ability to form coherent thoughts. The impact of solitary confinement is not just psychological, but also physical. Prisoners subjected to long-term isolation often suffer from weakened immune systems, chronic headaches, muscle atrophy, and cardiovascular problems due to lack of movement and exercise. The stress of isolation also increases the risk of high blood pressure and heart disease. In some cases, detainees in Belmarsh have been denied proper medical care, exacerbating their suffering and putting their lives at risk. What makes the use of solitary confinement in Belmarsh particularly disturbing is that it is often used not as a response to violent behavior but as a method of punishment and control, particularly for high-profile detainees who have embarrassed or exposed the government. These individuals are placed in conditions that are designed to break them mentally and physically, ensuring that their spirits are crushed and their ability to fight back is diminished. In this way, solitary confinement becomes not just a form of incarceration but a deliberate strategy to silence dissent. The United Nations has repeatedly condemned the use of prolonged solitary confinement, stating that any isolation lasting more than 15 consecutive days constitutes torture. Yet in Belmarsh, some prisoners have been held in these conditions for months or even years. The UK, which often criticizes other countries for human rights abuses, is itself violating international human rights standards by allowing this practice to continue. This hypocrisy weakens its moral authority on the global stage and raises serious questions about its commitment to justice and human rights. The use of solitary confinement in Belmarsh also has wider implications for the rule of law and the fairness of the UK's justice system. When a country that claims to uphold democracy and human rights engages in practices that are universally recognized as inhumane, it sets a dangerous precedent. It suggests that even in so-called democratic societies, those who challenge power can be subjected to extreme forms of punishment without accountability. The normalization of solitary confinement in Belmarsh is not just a failure of the prison system but a failure of the entire legal and political structure that allows it to persist. One of the most alarming aspects of Belmarsh Prison is the way it has become a symbol of legal injustice, where fundamental rights such as due process, fair trials, and legal representation are frequently undermined. While the UK prides itself on having a justice system rooted in fairness and transparency, Belmarsh exposes the contradictions within that system. Many detainees in the prison, particularly those facing politically sensitive charges, are subjected to legal proceedings that raise serious concerns about impartiality, judicial independence, and the abuse of legal frameworks to achieve predetermined outcomes. For individuals held in Belmarsh, access to fair legal proceedings is often obstructed. Some detainees are subjected to lengthy pretrial detention without being formally convicted of any crime, spending years behind bars while their legal battles drag on. Others face court proceedings where critical evidence is kept secret, withheld from both the defendant and the public under the guise of national security. This practice, often used in cases involving whistleblowers or political dissidents, prevents proper legal defense and ensures that the accused cannot fully challenge the charges against them. When evidence is hidden from scrutiny, the possibility of wrongful imprisonment becomes dangerously high. Additionally, legal teams representing detainees in Belmarsh frequently report obstacles in accessing their clients. Lawyers have described difficulties in arranging confidential meetings, excessive delays in receiving case-related documents, and surveillance measures that violate attorney-client privilege. In a fair justice system, the right to legal counsel is fundamental. Yet in Belmarsh, these rights are often curtailed, leaving detainees in a state of legal limbo where they are unable to properly defend themselves. The conditions in which detainees are held further contribute to legal injustices. The extreme isolation, lack of adequate medical care, and psychological toll of imprisonment in Belmarsh severely impact a detainee's ability to participate effectively in their own legal defense. Many are subjected to prolonged solitary confinement, which weakens their mental and emotional state, making it even more difficult for them to engage in legal proceedings. Some detainees suffer from declining health, yet they are still expected to appear in court or participate in complex legal battles while struggling under these oppressive conditions. This creates an unfair advantage for the prosecution, as the accused are placed in a physically and mentally weakened state before they even enter the courtroom. Furthermore, the use of extradition proceedings in Belmarsh-related cases has raised major concerns about the erosion of sovereignty and the prioritization of political interests over justice. Some detainees are held under legal processes that make it easier for them to be extradited to foreign jurisdictions where they may face harsher punishments, unfair trials, or even worse prison conditions. The extradition process itself often appears biased, with judges seeming to favor governmental and international political interests rather than impartially weighing the legal merits of a case. In some cases, individuals have been denied the right to present key arguments against extradition, further highlighting the lack of due process. The role of the media in shaping public perception of Belmarsh detainees also contributes to legal injustices. Many individuals held in Belmarsh are demonized in the press long before they have had a chance to defend themselves in court. Sensationalist headlines, biased reporting, and government narratives often paint detainees as criminals before any verdict has been reached. This kind of trial by media can influence judges, juries, and the broader public, creating a hostile environment in which the accused are presumed guilty rather than innocent. The presumption of innocence is a cornerstone of any just legal system, yet for many detainees in Belmarsh, this principle is abandoned in favor of political expediency and public pressure. Additionally, international legal bodies and human rights organizations have repeatedly criticized the legal processes associated with Belmarsh. Reports from groups such as Amnesty International and the United Nations have highlighted the systemic issues within the prison and the broader UK justice system that enable these injustices to continue. Despite these criticisms, there has been little political will to address the fundamental flaws in how detainees are treated, particularly when the cases involve individuals who have challenged state power. The erosion of fair trial rights in Belmarsh is not just an issue for those currently detained. It sets a dangerous precedent for the future. When governments are allowed to manipulate the legal system to target individuals who expose uncomfortable truths or challenge authority, the very foundation of justice is at risk. If these injustices are permitted to continue, it sends a clear message that legal protections exist only for those who do not threaten the status quo. A free press is one of the cornerstones of democracy. Journalists and whistleblowers serve as watchdogs, exposing corruption, government misconduct, and human rights abuses. They provide the public with crucial information that allows citizens to hold those in power accountable. However, when journalists and whistleblowers are imprisoned, especially in high-security facilities like Belmarsh, democracy itself is under threat. The moment a society begins to punish those who reveal the truth, it takes a dangerous step toward authoritarianism. Belmarsh Prison has become a symbol of this growing crackdown on press freedom. While it was originally designed to house dangerous criminals, it now holds individuals whose only crime is exposing inconvenient truths. By imprisoning journalists and whistleblowers, the UK government is sending a chilling message. If you expose wrongdoing, you will pay the price. This not only violates the principles of justice and free speech, but also discourages others from speaking out, leading to a culture of fear and silence. The imprisonment of truth-tellers undermines the very fabric of democracy by restricting the flow of information. A well-informed public is essential for a functioning democratic society, yet when journalists and whistleblowers are locked away, vital information is suppressed. Governments justify these actions under the pretext of national security, claiming that leaks of classified information endanger the country. However, history has shown that the real reason behind such imprisonments is often to prevent the exposure of illegal or unethical actions by those in power. When state authorities control what information is allowed to reach the public, democracy becomes nothing more than a facade. Additionally, the imprisonment of journalists and whistleblowers in facilities like Belmarsh sets a dangerous international precedent. When a democratic nation like the UK engages in the persecution of truth-tellers, it emboldens authoritarian regimes around the world. Countries with poor human rights records can point to the UK's actions as justification for their own crackdowns on journalists. It weakens the UK's ability to advocate for press freedom globally when it is actively violating those very principles at home. Moreover, the treatment of these detainees within Belmarsh is inhumane and designed to break their spirit. They're often placed in solitary confinement, isolated from their families and legal teams, and subjected to harsh prison conditions that are meant to serve as a warning to others. The psychological toll of such imprisonment can be devastating, leading to severe mental health deterioration, depression, and in some cases, even suicidal thoughts. For individuals who have not committed violent crimes, such treatment is not only unjust, but a clear violation of human rights. The suppression of journalists and whistleblowers through imprisonment also has long-term consequences for investigative journalism as a whole. When governments demonstrate that they are willing to imprison those who uncover uncomfortable truths, fewer journalists will be willing to take risks. This leads to self-censorship, where reporters avoid covering controversial topics for fear of legal repercussions. Over time, this erodes the role of the press as a check on power, allowing corruption and abuses to go unchecked. Without fearless investigative journalism, democracy weakens, and the people lose their ability to challenge authority. Furthermore, the legal processes used to imprison journalists and whistleblowers are often deeply flawed, relying on outdated espionage laws, secret court hearings, and manipulated evidence. Many of these cases are handled in ways that deny the accused a fair trial, restricting their ability to defend themselves in court. Governments use legal loopholes to ensure that journalists and whistleblowers are treated as criminals rather than individuals who have acted in the public interest. This deliberate distortion of the law transforms justice into a weapon against truth. The imprisonment of journalists and whistleblowers in Belmarsh is not just about punishing individuals, it is about setting an example. By making high-profile cases out of those who expose corruption, governments seek to deter future leaks and investigative reporting. It is a calculated effort to instill fear in those who might otherwise come forward with important information. However, history has shown that truth cannot be permanently suppressed. Even when governments attempt to silence journalists and whistleblowers, their revelations often find a way to reach the public, exposing the very injustices they sought to hide. The question we must ask ourselves is this: if exposing war crimes, corruption, and government misconduct is treated as a crime, what does that say about the state of democracy? The imprisonment of journalists and whistleblowers in Belmarsh is not just an attack on individuals, it is an attack on the public's right to know. The UK government frequently invokes national security as the primary justification for the extreme measures used in Belmarsh Prison. It argues that certain individuals pose a grave threat to the safety of the nation, requiring them to be held under the strictest conditions. However, while the term national security carries weight, it is often used in vague and opaque ways that prevent public scrutiny. This lack of transparency raises serious concerns about the abuse of power and the potential for human rights violations under the guise of protecting the country. One of the main issues with using national security as a blanket justification is that it allows the government to operate without proper oversight. Many of the cases involving detainees in Belmarsh are shrouded in secrecy, with limited access to court records, restricted media coverage, and classified evidence that cannot be fully examined by defense teams. This secrecy undermines the basic principles of justice, as it prevents independent review and accountability. If the government is confident in its claims that these individuals are a danger to society, then why not allow greater transparency in legal proceedings? The answer lies in the fact that much of what happens in Belmarsh would not withstand public scrutiny. Furthermore, history has shown that governments have a tendency to misuse the concept of national security to suppress dissent rather than to genuinely protect their citizens. Throughout the 20th and 21st centuries, various democratic nations have engaged in practices such as mass surveillance, indefinite detention, and targeted persecution under the pretense of national security. The UK is no exception. In Belmarsh, individuals who have exposed government misconduct or challenged state authority are often treated as threats, not because they have committed violent acts, but because they have revealed inconvenient truths. By labeling these individuals as dangers to national security, the government is able to justify their harsh treatment without having to provide a compelling public case for their imprisonment. Additionally, the broad and ambiguous use of national security laws means that even non-violent individuals can be subjected to the same extreme conditions as convicted terrorists and dangerous criminals. The UK's legal framework allows for prolonged detention without charge under certain circumstances, meaning that individuals can spend months or even years in Belmarsh without ever being found guilty of a crime. This creates a disturbing situation where the mere suspicion of being a national security threat is enough to strip someone of their basic rights. The reliance on secrecy also makes it difficult for the public to assess whether the measures used in Belmarsh are truly necessary. Governments often claim that revealing too much information about national security cases would put the country at risk. While there are legitimate reasons to protect certain sensitive information, this argument is often used to prevent accountability rather than to safeguard the nation. If democratic institutions cannot question or challenge government actions in the name of security, then the very principles of democracy and rule of law are undermined. Moreover, the government's justification for Belmarsh's extreme conditions ignores the mounting evidence that such harsh treatment does little to improve security. Studies have shown that prolonged isolation and inhumane detention practices can radicalize individuals, breed resentment, and create conditions for further instability. Rather than making the country safer, these measures can contribute to long-term societal harm. If the goal is to protect national security, then justice must be applied fairly, and the principles of human rights must be upheld even in cases involving national security concerns. The lack of transparency surrounding Belmarsh also extends to international accountability. The UK presents itself as a nation that upholds human rights and democratic values on the world stage. It criticizes other countries for human rights abuses, yet it continues to operate a prison that mirrors some of the worst aspects of secretive detention facilities found in authoritarian states. This hypocrisy weakens the UK's credibility in advocating for democracy and human rights abroad. If the government truly believes in these principles, then it must be willing to apply them consistently, even when dealing with cases labeled as national security threats. Additionally, the invocation of national security to justify extreme detention measures sets a dangerous precedent for future cases. If the government can use these powers today to imprison journalists, whistleblowers, and political dissidents, then who is to say that these powers will not be expanded in the future? When a government is given unchecked authority to detain individuals under vague security laws, there is always a risk that these measures will be used against an ever-expanding group of people. History has shown that once governments normalize extreme security measures, they rarely roll them back. Instead, they find new reasons to apply them more broadly. The argument that extreme measures in Belmarsh are necessary for national security also ignores the fundamental question of whether these practices align with the values of justice and human dignity. If national security comes at the cost of basic human rights, then what kind of security is truly being protected? If a government must resort to secrecy, indefinite detention, and the suppression of information to maintain its power, then it is not safeguarding democracy, it is eroding it. The continued justification of Belmarsh's extreme conditions under the guise of national security should concern anyone who values freedom, justice, and accountability. When a government is allowed to operate in secrecy, detain individuals without due process, and label dissenters as security threats, democracy itself is placed in jeopardy. Without transparency and oversight, the national security argument becomes little more than a tool for oppression rather than a genuine effort to protect the public. One of the most troubling aspects of Belmarsh Prison is the glaring lack of accountability and independent oversight. In any democratic society, prisons and law enforcement agencies must operate under strict scrutiny to ensure that human rights are upheld and that no individual is subjected to unlawful or inhumane treatment. However, Belmarsh exists in a shadowy space where transparency is severely lacking, allowing abuses to occur without consequence. The absence of meaningful oversight enables a culture of impunity, where prison authorities and government officials can act without fear of accountability. At the heart of this problem is the fact that Belmarsh, despite being a high-security prison, operates with minimal external monitoring. While there are official bodies tasked with inspecting prisons, their ability to enforce real change is limited. Reports of inhumane conditions, prolonged solitary confinement, denial of medical care, and psychological abuse have surfaced repeatedly, yet little is done to address these concerns in a meaningful way. The mechanisms that should ensure justice, such as independent prison inspections, legal reviews, and human rights watchdogs, are either restricted, ignored, or dismissed by those in power. One of the key reasons for this lack of oversight is the way national security is used as a shield to deflect criticism. The UK government has repeatedly argued that Belmarsh houses individuals who pose a threat to national security and therefore, certain measures must be taken to maintain control. This argument conveniently allows the authorities to restrict access to information, limit the involvement of human rights organizations, and silence concerns raised by legal experts. When security concerns override transparency, it creates an environment where abuses can occur without public knowledge or accountability. The secrecy surrounding Belmarsh extends beyond its walls and into the legal system itself. Many of the individuals held in the prison, particularly those facing extradition or politically motivated charges, are subjected to legal proceedings that lack transparency. Secret court hearings, classified evidence, and restricted media access prevent the public from fully understanding what is happening. When the justice system operates behind closed doors, it prevents external scrutiny and makes it nearly impossible to challenge wrongful imprisonment or inhumane treatment. This lack of accountability also extends to the treatment of prisoners within Belmarsh. Reports have surfaced detailing instances of physical abuse, psychological torment, and medical neglect, yet prison authorities face little to no consequences. Some detainees have been denied access to proper health care, resulting in severe deterioration of their physical and mental well-being. Others have been kept in solitary confinement for prolonged periods, a practice that has been condemned by the United Nations as a form of torture. Yet despite these clear violations of human rights, prison officials are rarely held accountable for their actions. International human rights organizations, including Amnesty International and the United Nations, have repeatedly raised concerns about the conditions in Belmarsh. However, their recommendations are often ignored, and the UK government continues to justify its actions under the pretext of national security. This selective disregard for human rights not only damages the UK's international reputation, but also sets a dangerous precedent that allows future governments to expand and abuse these powers even further. The lack of independent oversight in Belmarsh also means that prisoners have very limited avenues to seek justice. Complaints from detainees regarding mistreatment are often dismissed or buried within bureaucratic processes. Legal teams representing these individuals face significant hurdles in gathering evidence, as access to clients is restricted and many crucial documents are classified. Without proper legal recourse, detainees are left in a position where they must endure mistreatment with no hope of intervention. The issue of impunity in Belmarsh is further exacerbated by the unwillingness of politicians and the judiciary to challenge the status quo. While some members of parliament and human rights activists have voiced concerns about the prison, there has been no significant political push to reform its practices or improve oversight. The judiciary, too, often defers to the government's claims of national security rather than rigorously examining the legality of the prison's treatment of detainees. This failure of political and legal institutions to act means that the injustices taking place within Belmarsh continue unchecked. Moreover, the media plays a role in this lack of accountability. While some independent journalists and activists have worked tirelessly to expose the abuses within Belmarsh, mainstream media coverage often echoes the government's narrative, portraying detainees as dangerous threats who deserve their treatment. Sensationalist reporting, combined with government-controlled messaging, helps to justify the lack of transparency and prevents widespread public outcry. When the media fails to critically examine human rights violations, it allows the government to act with even greater impunity. The absence of meaningful oversight in Belmarsh is not just an isolated issue. It reflects a broader trend of increasing authoritarianism in democratic nations. When governments are allowed to detain individuals without full transparency, when prisons operate without accountability, and when human rights violations are excused in the name of security, the foundations of democracy itself are eroded. If Belmarsh can function with impunity today, what is to stop future governments from expanding these practices and applying them to an even wider range of individuals? The normalization of unchecked power within the prison system is a warning sign of deeper systemic failures that threaten justice for all. Belmarsh Prison has gained infamy not just for the high-profile individuals it holds, but for the extreme and inhumane conditions in which many of its detainees are kept. Among the most disturbing aspects of life in Belmarsh is the routine use of solitary confinement and psychological torture, practices that violate basic human rights and have been condemned by international organizations, including the United Nations. Despite the UK's claims to uphold the rule of law and human dignity, the treatment of prisoners in Belmarsh paints a very different picture, one in which suffering is inflicted not as a means of justice, but as a form of punishment, control, and even retribution. Solitary confinement in Belmarsh is not reserved solely for dangerous criminals or violent offenders. It is frequently used against detainees who have not been convicted of any crime, particularly those awaiting trial or extradition. Some detainees spend 22 to 23 hours a day in a small, windowless cell, with minimal human contact and little to no access to sunlight or fresh air. The effects of such extreme isolation are well documented. Studies have shown that prolonged solitary confinement can lead to severe psychological distress, anxiety, depression, hallucinations, and suicidal thoughts. Yet, despite the overwhelming evidence that such treatment constitutes psychological torture, Belmarsh continues to impose these conditions on its detainees. The justification given for solitary confinement varies. In some cases, authorities claim that it is necessary for security reasons, arguing that certain detainees pose a high risk to the prison population. However, many of those subjected to these conditions are nonviolent individuals who have no history of posing any physical threat. In other cases, solitary confinement is imposed under the guise of protective custody, a claim that is often used to mask the fact that the real purpose is to isolate and break the spirit of those held inside. One of the most alarming aspects of Belmarsh's use of solitary confinement is its psychological impact on detainees. The human mind is not designed to endure prolonged isolation. Deprived of meaningful social interaction, many prisoners experience rapid mental decline. Anxiety disorders, paranoia, and post-traumatic stress disorder, PTSD, are common. Some detainees report losing their sense of time, struggling to differentiate between day and night. Others have described hearing imaginary voices, experiencing intense mood swings, and suffering from uncontrollable panic attacks. These are not the signs of individuals becoming rehabilitated or prepared for reintegration into society. They are the symptoms of a system designed to psychologically break those it imprisons. The psychological toll of Belmarsh's conditions is made even worse by the deliberate deprivation of basic needs. Prisoners in solitary confinement often report being denied access to books, television, or even simple activities that could provide some mental stimulation. Many are prevented from engaging in meaningful exercise, forced instead to pace back and forth in their tiny cells. Phone calls and visits from family members are strictly limited, cutting prisoners off from the outside world and deepening their sense of despair. Some detainees have even been denied access to proper health care, exacerbating pre-existing conditions and leading to serious medical complications. Perhaps most disturbingly, solitary confinement in Belmarsh is often used as a means of coercion. Prison authorities have been known to use the threat of isolation to force detainees into compliance, whether that be in relation to legal proceedings, plea deals, or other forms of cooperation. This tactic is particularly concerning in cases involving whistleblowers and journalists, where isolation is used not only as punishment, but as a tool to suppress information and silence those who have spoken out against powerful institutions. The United Nations Special Rapporteur on Torture has explicitly stated that solitary confinement beyond 15 days constitutes torture due to its irreversible psychological effects. Yet in Belmarsh, some detainees have been subjected to these conditions for months or even years. The failure of the UK government to address this issue, despite repeated warnings from human rights organizations, raises serious questions about the country's commitment to international human rights standards. The psychological torment inflicted by Belmarsh does not end with solitary confinement. Detainees are frequently subjected to conditions designed to induce stress, anxiety, and a sense of helplessness. Constant surveillance, The arbitrary denial of privileges, sudden transfers within the facility, and the unpredictability of their legal status all contribute to an environment of perpetual fear and uncertainty. Some detainees describe the experience as being in a state of legal limbo, where they do not know how long they will be imprisoned or whether they will ever receive a fair trial. The effects of psychological torture extend far beyond the prison walls. Even those who are eventually released often struggle with long-term mental health consequences. Many suffer from chronic depression, paranoia, and an inability to reintegrate into normal life. Some develop severe trust issues, having spent years in an environment where they were constantly watched, manipulated, and deprived of basic human contact. The damage inflicted by such treatment is not easily undone, and in many cases, it lasts a lifetime. Despite the overwhelming evidence that these practices violate human rights, there has been little effort by the UK government to address the situation. Officials continue to justify the extreme conditions at Belmarsh in the name of national security, disregarding the suffering of those held inside. This failure to act not only damages the UK's credibility on the global stage, but also sets a dangerous precedent for the normalization of psychological torture within the prison system. The ongoing use of solitary confinement and psychological torture in Belmarsh raises an urgent moral and legal question. If a democratic country like the UK allows such practices to continue unchecked, what does that say about the true state of its justice system? When a nation that claims to uphold human rights is willing to subject individuals, many of whom have not even been convicted of a crime, to conditions recognized as torture, it exposes a deep and troubling hypocrisy. If these practices are allowed to continue, they will not only damage the lives of those currently imprisoned, but will erode the fundamental values that democracy is supposed to stand for. Belmarsh Prison has long been the subject of scrutiny by international organizations, human rights advocates, and legal experts who have condemned its harsh conditions and the treatment of its detainees. Despite their efforts to expose the injustices taking place within its walls, these groups have faced significant resistance from the UK government and prison authorities. The refusal to allow proper oversight, the suppression of critical reports, and the dismissal of international concerns reveal a troubling pattern, one in which the UK attempts to shield itself from accountability rather than addressing the fundamental human rights violations occurring within its most infamous prison. Organizations such as Amnesty International, Human Rights Watch, and the United Nations have repeatedly raised alarms about the conditions in Belmarsh. Reports from these groups have documented severe mistreatment, including prolonged solitary confinement, denial of medical care, psychological torture, and restrictions on legal access. The UN Special Rapporteur on Torture, after conducting an investigation, has even compared the treatment of some detainees in Belmarsh to conditions found in the most repressive regimes. However, rather than acknowledging and addressing these findings, the UK government has often dismissed them outright or attempted to downplay their significance. One of the most striking examples of this resistance is the UK's failure to implement recommendations from international bodies regarding prison conditions. The UN has called for urgent reforms in Belmarsh, including the prohibition of prolonged solitary confinement, improved access to healthcare, and greater transparency in legal proceedings. Yet, time and again, these recommendations have been ignored or inadequately addressed. Instead of responding with meaningful reforms, the UK government has either denied the severity of the situation or justified its actions under the broad and ambiguous claim of national security. This refusal to engage in dialogue with international human rights advocates not only exacerbates the suffering of those imprisoned, but also undermines the credibility of the UK's commitment to human rights on the world stage. The resistance to human rights scrutiny is not limited to dismissing reports. It also extends to restricting access for investigators and legal observers. International human rights groups have faced significant obstacles when trying to visit detainees or conduct independent assessments of prison conditions. Requests for access are often delayed, heavily restricted, or outright denied, preventing these organizations from gathering first-hand evidence of mistreatment. When visits do occur, they are typically controlled and monitored by prison authorities, ensuring that detainees cannot speak freely about the abuses they have endured. This deliberate obstruction makes it extremely difficult for human rights advocates to hold the UK government accountable for the violations taking place in Belmarsh. In addition to resisting oversight, the UK has also attempted to discredit those who speak out against Belmarsh's practices. Human rights advocates, lawyers, and even UN officials who have criticized the prison have faced attacks on their credibility, with government representatives accusing them of being biased or misinformed. This tactic of discrediting critics serves a dual purpose. It weakens the impact of their findings while also discouraging others from investigating or speaking out. By casting doubt on the legitimacy of human rights concerns, the UK government effectively shields itself from accountability while continuing its harsh detention practices. Furthermore, the UK's resistance to international scrutiny has wider implications beyond Belmarsh itself. When a country that presents itself as a champion of democracy and human rights refuses to be held accountable for its own violations, it sets a dangerous precedent. Other governments, particularly authoritarian regimes, can point to the UK's actions as justification for their own human rights abuses. If a democratic nation like the UK can dismiss UN recommendations, restrict access to detainees, and justify harsh treatment under the guise of security, then what is to stop other countries from doing the same, on an even larger and more brutal scale? Despite the resistance, human rights organizations and legal advocates continue to fight for greater transparency and accountability in Belmarsh. Campaigns to expose the prison's abuses have gained global attention, with protests, legal challenges, and public awareness efforts shedding light on the suffering endured by detainees. Lawyers representing those held in Belmarsh have brought cases before international courts, arguing that the UK's actions violate human rights treaties to which it is legally bound. The persistence of these efforts proves that, despite the government's attempts to resist scrutiny, the fight for justice continues. One of the most crucial aspects of this fight is the role of whistleblowers and former detainees who have come forward to share their experiences. Their testimonies provide critical first-hand evidence of the inhumane conditions inside Belmarsh, exposing details that would otherwise remain hidden from public view. However, these individuals often face significant risks when speaking out, including legal threats, surveillance, and character attacks. The fact that they are willing to endure such risks speaks to the severity of the abuses taking place and the urgent need for accountability. The UK's resistance to international oversight also raises serious legal and ethical questions. As a signatory to various human rights treaties, including the European Convention on Human Rights and the UN Convention Against Torture, the UK has a legal obligation to uphold fundamental human rights standards. Yet, by ignoring the findings of international bodies, obstructing investigations, and continuing to impose harsh conditions on detainees, it is actively violating these commitments. This contradiction between the UK's legal obligations and its actions at Belmarsh is a glaring example of the gap between rhetoric and reality when it comes to human rights enforcement. Additionally, the suppression of human rights concerns in Belmarsh has contributed to a broader culture of secrecy and impunity within the UK's justice system. If violations are allowed to continue without consequence, it normalizes the idea that certain individuals, especially those labeled as security threats, can be subjected to treatment that would be deemed unacceptable for anyone else. This erosion of legal and ethical standards does not just affect those currently imprisoned in Belmarsh. It threatens the integrity of the entire justice system, opening the door for further abuses in the future. The international condemnation of Belmarsh is a direct challenge to the UK's self-image as a defender of human rights and democracy. If the UK wishes to maintain its credibility on the world stage, it must engage with these criticisms rather than resisting them. True democratic accountability requires that no institution, no matter how powerful, be allowed to operate without scrutiny. Until meaningful reforms are made, Belmarsh will remain a symbol of hypocrisy, where human rights are disregarded in favor of secrecy, punishment, and political convenience. The existence of Belmarsh Prison, with its severe conditions, lack of transparency, and use of solitary confinement, raises profound questions about the state of justice, democracy, and human rights, not just in the UK, but across the world. A nation that prides itself on upholding the rule of law and defending human rights should not operate a facility that mirrors the worst excesses of authoritarian regimes. Yet, Belmarsh remains a stark example of how even democratic countries can create spaces where fundamental rights are systematically denied, all under the guise of national security. One of the most alarming implications of Belmarsh's existence is the erosion of the principle that justice must be applied fairly and universally. The rule of law is meant to ensure that no individual is subjected to cruel or degrading treatment, regardless of the accusations against them. However, Belmarsh represents a dangerous shift, where certain individuals, particularly those deemed politically inconvenient or a threat to state interests, are treated outside the normal bounds of justice. This selective application of legal protections sets a precedent that weakens the integrity of the entire judicial system. If one group of people can be detained under extreme conditions without due process, what is to stop the same tactics from being used against others in the future? Belmarsh also highlights the increasing use of national security as a justification for human rights abuses. Governments around the world have long relied on the rhetoric of threats to national security to justify exceptional measures, from mass surveillance to indefinite detention. The UK's treatment of Belmarsh detainees fits into this pattern, allowing authorities to override basic human rights protections under the broad and often unchallengeable claim that certain individuals are too dangerous to be afforded fair treatment. This is particularly troubling because it creates a slippery slope. Once governments establish the precedent that security concerns justify the erosion of legal norms, it becomes easier to expand those powers in the future, often at the expense of ordinary citizens. Moreover, Belmarsh's existence signals a growing acceptance of authoritarian-style detention practices in countries that claim to uphold democratic values. The idea that Western democracies do not engage in indefinite detention, political persecution, or psychological torture is a comforting illusion, but Belmarsh exposes the reality that these practices are alive and well, even in nations that lecture others on human rights. If the UK, a country that frequently condemns human rights violations abroad, can operate a prison with conditions comparable to Guantanamo Bay, what credibility does it have when calling out other nations for similar abuses? This hypocrisy damages the UK's standing on the global stage, undermining its moral authority when advocating for democracy and human rights in places like China, Russia, or the Middle East. Belmarsh also represents a fundamental betrayal of the principles enshrined in international human rights agreements. The UK is a signatory to treaties such as the European Convention on Human Rights, ECHR, and the United Nations Convention Against Torture. These agreements are meant to ensure that all individuals, regardless of their alleged crimes, are treated with dignity and given a fair trial. Yet, by allowing Belmarsh to operate as a high-security black hole where detainees suffer inhumane treatment, the UK is actively violating these commitments. This raises serious questions about the enforceability of international human rights laws. If a country like the UK can ignore them without consequences, what does that mean for the future of human rights enforcement worldwide? Another critical implication of Belmarsh's existence is its chilling effect on press freedom and political dissent. Some of the most high-profile individuals held in Belmarsh are not violent criminals, but journalists, whistleblowers, and political dissidents whose real crime was exposing government misconduct. Their imprisonment sends a clear message. Those who challenge powerful institutions risk being silenced, not through debate or legal arguments, but through imprisonment in a facility designed to break them physically and psychologically. This has a ripple effect beyond the prison walls. When governments use extreme detention practices against those who expose the truth, it discourages others from speaking out. Journalists may think twice before publishing sensitive information, activists may hesitate before challenging state policies, and whistleblowers may decide that revealing corruption or war crimes is simply too dangerous. The result is a society where power goes unchecked and the fundamental democratic principle of accountability is eroded. The use of prolonged solitary confinement and psychological pressure in Belmarsh also has broader implications for the future of incarceration and state control. Prisons have always reflected the priorities of the societies that build them. A justice system that embraces isolation, secrecy, and harsh treatment is one that values control over rehabilitation, fear over fairness. When these practices are normalized in high-profile cases, they become easier to justify in the wider prison system. If Belmarsh can subject detainees to such extreme conditions, what prevents other prisons from adopting similar tactics? The line between political prisoners and ordinary inmates becomes blurred, and before long, the harshest elements of Belmarsh's regime may spread to the wider carceral state, affecting thousands of people who were never meant to be treated as exceptional cases. Beyond the UK, Belmarsh's practices serve as a model for other governments looking to expand their own powers of detention. Authoritarian regimes can point to the UK's treatment of detainees in Belmarsh as justification for their own abuses. If a Western democracy can imprison individuals under conditions widely condemned as inhumane, then what moral argument can be made against similar actions elsewhere? This creates a race to the bottom, where governments worldwide adopt increasingly repressive measures while citing the actions of countries like the UK as precedent. Furthermore, the existence of Belmarsh calls into question the very meaning of justice in a modern democracy. A justice system should be transparent, impartial, and focused on rehabilitation rather than punishment. But Belmarsh embodies the opposite: secrecy, cruelty, and an emphasis on breaking detainees rather than ensuring fair treatment. This raises the question: if even the UK, with its long history of democratic institutions, can maintain a prison that operates in such a manner, what does that mean for the global struggle for justice? If one of the world's leading democracies can justify inhumane detention practices, what hope is there for nations where democracy is far weaker? Belmarsh Prison is more than just a high-security facility. It is a symbol of injustice, secrecy, and the erosion of human rights in a nation that claims to uphold the rule of law. The conditions within its walls, the treatment of its detainees, and the resistance to international scrutiny all point to a system that prioritizes power and control over fairness and due process. If Belmarsh is allowed to continue operating under these inhumane conditions, it sets a dangerous precedent, not just for the UK, but for democracies around the world. The fight against injustice does not end at the prison gates. It is the responsibility of human rights advocates, legal experts, journalists, and ordinary citizens to continue exposing the truth about Belmarsh and demanding accountability. The UK government must be held to the same standard it expects from others. It cannot condemn human rights abuses abroad while maintaining a facility that mirrors the worst excesses of authoritarian regimes at home. Justice must not be reserved for the powerful while being denied to those who challenge authority. If Belmarsh is to remain part of the UK's legal system, it must be reformed to reflect the principles of fairness, dignity, and human rights. Otherwise, it will continue to stand as a dark stain on the country's justice system, a stark reminder that, in the pursuit of power, even the most fundamental rights can be ignored. The world is watching. It is time for the UK to decide whether it will uphold the values of democracy and justice or whether it will allow Belmarsh to remain its own Guantanamo Bay, an institution built on secrecy, suffering, and silence.